on Senate Bill 127. That is expanding the hearsay exception for statements made to a physician to all healthcare providers. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 127 amends KSA 6460. That's the statute that defines hearsay. And it also provides for the exceptions to the general rule that hearsay evidence is not admissible. Current law in subsection L there provides the exception for statements made to a physician. It provides that unless a judge finds that it's made in bad faith, a statement of the declarant's either then existing state of mind, emotion, or physical sensation, including statements of intent, plan, motive, design, mental feeling, pain, and bodily health, but not including memory or belief to prove the fact remembered or believed when such mental or physical condition is an issue or is relevant to prove or explain acts or conduct of the declarant or previous symptoms, pain, or physical sensation made to a physician consulted for treatment or for diagnosis with a view to treatment and relevant to an issue of the declarant's bodily condition would be admissible. This bill changes that term physician to healthcare provider as defined in 654915 to expand that to more healthcare providers than just physicians. And I can take any questions.
Thank you. Natalie, is the amendment to the statute, is it just the part on page 3 or?
Yes, Madam Chair. That is the change there on page 3. In the Civil Procedure Code, we have those captions that are italicized, so that can get kind of confusing. It looks like they're new language. Those are not new language. They're in current law. The only change is on page 3, starting at line 19.
Thank you. Lines 19 and 20 through 21.
Yes.
Great. Thank you. Committee, any questions? Not seeing any. Thank you. Appreciate it. First, we will hear from proponent Conferee Aaron Breitenbach, Deputy District Attorney on behalf of Mark Bennett, District Attorney, 18th Judicial District, and the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and fellow committee members. I'm Aaron Breitenbach, Deputy District Attorney here in Sedgwick County, and as stated, I'm here on behalf of not just our office, but the Kansas County District Attorneys Association across the state. As the reviser shared, the bill itself is relatively straightforward. As discussed in the written testimony, as most of us have experienced, when we go to the doctor, whether it's for a normal checkup or an urgent care situation or an ER, the first person we talk to and the person we spend most of our time with is not a physician, right? It's the nurse, it's an LPRN, it's any number of other medical professionals who take down our symptoms, our description of how an injury might have occurred, things of that nature, and that testimony or those statements are precisely what this hearsay exception was intended to capture, with the idea being a person seeking medical treatment is less likely to make up their symptoms or how an injury occurred or what their medical history is that might have contributed to whatever they're there for. There's an inherent reliability in that, right? Why would you make up something, in that context? Because your nurse, your doctor, it's not a police officer who's going to go arrest someone or take any other action against that person. Their only interest is in treating you. So there's an inherent, at least as the legislature has acknowledged, and not just in Kansas, but in many other states, that there is an inherent reliability to that conversation. This amendment just seeks to mirror the reality that those statements are actually most often made to non-physicians, or at a minimum to include all those people, because as we know throughout the state, many people never actually meet a doctor, an actual physician. They get their care through other medical professionals, and so that's what this amendment seeks to address. To be clear, this rule would apply for anyone, right? So it's not just prosecutors who benefit from this, but it's anyone, defense in the criminal case, civil cases, whatever, who are seeking to introduce this information. Again, just trying to create a fuller picture of who is receiving this information from those who are hurt in our communities, so that those statements might be available if for some reason they are not. With that, I don't think I have any other explanation, and obviously would stand for questions as you choose.
Thank you. Are there any other proponents wishing to testify in support of the bill? Not seeing any, then we'll open it up for questions. Any questions? Yes, Senator Titus.
Thank you, Madam Chair. Mr. Breinbach, when I look at your change and the reference to KSA 654915, that's an exceptionally broad list. Now that, you know, my dentist now has a hearsay exception under this, and then there's even a reference to 403401, which has a list of technically now a medical partnership under your bill now has a hearsay exception. However, we make that corporate person subject to the hearsay rule. It just seems like you haven't put very much of the scalpel, if you will, into setting this up.
Well, again, the purpose of the rule is that if someone is sharing their medical history information, whoever that trusted person is in this context, that there's a reliability to that statement. So I'm not, I guess I'm not sure what scalpel would be appropriate when the nature of the conversation is the same. If I'm going to share, you know, my medical history, you know, how I got hurt, how long I've had these symptoms, the severity of my symptoms, etc. I'm doing that because I'm wanting help with those symptoms. So that's been the purpose behind this for as long as this exception has existed. It just existed in a time where I think most people primarily talk to doctors, and as you've indicated, we are now primarily, you know, the example of the dentist, right? So let's say I'm a domestic violence victim and I'm going to get a crown replaced because my domestic partner, you know, punched my face and broke my jaw. I might share the circumstances and when that happened. How long ago did it happen? Whatever. So you can see how non-doctors, in that medical doctor sense, might receive statements that speak to how an injury occurred, that under the policy of this statute should be available if for some reason I become incapacitated or no longer available to testify. But to be clear, it doesn't do anything to change the privilege that exists, right? So it's not like my dentist can then go around and just talk about, well, Aaron shared all these things with me yesterday. This doesn't do anything to any of those protections. It just speaks to if for some reason I no longer am available, or, well, let's just stay there. Someone could tell my story if it's shared within that context of seeking medical treatment.
Thank you.
Thank you. I want to follow up on that question just a little bit. So the hearsay rule is you can't make, it doesn't come into evidence if it's an out-of-court statement offered for the truth of the matter asserted in the statement. And it's, would you agree it's a pretty hard, it's hard to overcome the hearsay rule unless there's an exception, because you can't say, you know, John told me that he did it, unless that would be, and if you're trying to prove John did it, that would be an out-of-court statement that John made to you, and you're offering it in court for the truth of the matter asserted in the statement that I'm saying John said that he did it. So the concern that some may have with this bill is that the scope of 654915 is pretty broad. I mean, you might be talking to your dentist and you might share, yeah, my hip hurts, you know, because it's just conversation you're having as you're, you know, talking with your dentist. My hip hurts because, you know, so-and-so pushed me down the stairs last week. And then would that then be a exception to the rule that you have to have John, who says, I did it, he has to come in the courtroom so he can be cross-examined? Because the purpose of the hearsay rule is you have an opportunity to cross-examine the person making the statement. So could you talk about, then your dentist can come in and testify, yeah, Susie told me her hip hurts because she was pushed down the stairs last week.
Right. So just to go back a second. So yeah, so the general concept of hearsay, as you said, is that a person said something to me, right? I'm there to testify to what this person told me. Well, that person, we'll say Gabe is his name. Well, Gabe's not here. And unless there's some reason why that statement would come in, what Gabe told me isn't admissible, right? That's hearsay. An exception, and there's a whole list, as was indicated, the statute has many, many, many exceptions. Those exceptions are generally all based on different circumstances where, by public policy, the legislature has recognized that Gabe wouldn't have told me that, but for some reason that makes that statement more credible. For example, Gabe confessing to a crime. Usually you're not going to confess to crimes because you could be in trouble for that. Maybe that's a more controversial exception because that's kind of what you shared. This one is based on the idea that I'm a care provider, a patient, and as the language says, the statement needs to be in the context of a person talking to me as a medical professional for treatment of their injury. So if I happen to be a nurse and I play golf with a friend, and my friend just shares to me, what
So
happened.
my question is, though, if you're at the dentist for treatment or diagnosis, like the bill says, for your tooth, but you happen to talk about your hip injury, would that fall within this hearsay exception? And then the dentist could testify? Because the reason hearsay is not admissible is because, especially in the criminal context, you have the right to confront the witnesses against you to test the statement. Did they really say that? What did they mean? So would the dentist be able to testify under this bill that your hip hurt because you were pushed down the stairs last week?
Conceivably, conceivably, and I suppose if that is and I guess I would still say, what's the harm in that, right? If I'm telling a medical professional, so the main distinction here is when I tell something to a police officer that directly or indirectly accuses someone else of a crime, there's the chance that I may have a motive in doing that because I know a police officer is going to do certain things with that, right? They're going to investigate it. They're going to go arrest someone. They're going to do something to that person potentially. When I say something to a medical professional, even if maybe it's not their treatment area of expertise, right? I say something to an orthopedic, but it has to do with something else. Again, I'm not a doctor, so I can't think of all the differences. But my point is, even if the person I'm talking to isn't the one who's best equipped to treat the particular injury that I'm speaking to, I'm saying it to a medical professional, right? What expectation would I have that medical professional is then going to go out and build some case against so and so? I'm saying it to that professional because they're a doctor or they have some medical training, and even if they don't know how to treat it, maybe they know who might be able to give me assistance. I mean, how many of us might say, "Hey, I've got this thing. I know it's not, you're not an oncologist, but can you tell me if this is a problem or not?" Right? But if the concern is that the person receiving the statement needs to at least be someone capable of treating the particular thing, maybe something could be put into that clause where it says consulted for treatment or diagnosis with a view to treatment of that, of that issue or of that injury, maybe, because then arguably you're limiting you're linking the professional to the injury, I suppose that's okay. But my concern about doing that is, well, a nurse or a nurse practitioner may only be authorized to treat certain things in a certain way. Maybe they can't prescribe the medication that you would need to treat this particular injury. Are we going to say that somehow, because they don't have a script pad, they can't then get me to the person who can prescribe the pain medication or can prescribe the amoxicillin or whatever it is that I need? Again, the purpose here is, regardless of whether the care provider is the best equipped to treat the harm, it's the person speaking to me is speaking to me in the context of me providing them medical care. And it is more inherently the likelihood of a person making something up to me when all I can do for them is medical care, decreases the likelihood that that person is making it up for some nefarious reason, right? Some untrustworthy reason. So I guess that's my long answer.
Well, thank you for that. I'm just looking through some of the opponent testimony, and when you broaden the category from physician, I mean, we know that physicians are professionals who've gone through rigorous programs, ethical examinations, who are trained to listen carefully and speak cautiously as the power their licenses gives their words. There's consequences if they misspeak, and if they want to be, they're licensed professionals. And the opponents raise that corporations would be considered healthcare providers, and that the bill would apply not just in the criminal context, but in every context in civil matters as well. So I don't have anyone on the civil side of the issue as a proponent of the bill. Do you have any comment that, representatives of a medical corporation could then come in, and they might not have had even direct person-to-person contact with the person who they're reporting the statement of? Well, and they weren't seen. So anyway, do you have any comment about that?
Well, yeah, I do, and I appreciate the opportunity. That's the difficulty when I appear remotely, is I don't have access to that opponent testimony as readily in advance. So I appreciate the opportunity to respond to that. Again, it requires that hearsay under these exceptions require that the statement is made to the person who's testifying to it, right?
Well, how do you do that if a healthcare corporation is included? I mean, you're just a representative of the corporation, and Susie told us in our corporate meeting that her hip hurts because she was pushed down the stairs last week.
Well, regardless of how broadly the definition is, and perhaps there could be some refinement of that, and if someone would like to suggest a smaller number of medical personnel, that's a worthwhile discussion. But
you'd be open to discussing that?
Yeah, 100%, sure. Because again, the problem is the varying, the medical profession keeps adding different types of practitioners, right? I mean, in the olden days, it was a nurse and it was a doctor, and that was it. Well, now we've got an alphabet soup of different permutations of different licensure. But the rule requires, or the statute requires, that the statement is made to one of those qualified personnel, and perhaps refinement of what that list is sounds like a concern and one would be open to addressing. But it requires a statement be made to that person in the context of medical treatment. So a person saying something in a board meeting in a corporate context clearly would not fit the rest of the language of the statute. So I think getting too caught up in the broad definition of who's receiving the information loses the context of the rest of the statute, which then says, but the communication needs to be in the context of this direct treatment relationship. And so reading it in its whole, it allows that broad definition to have a clearer meaning. But if the concern is that in the effort, because the problem is we don't want to keep coming back to the statute, right? So if a new licensure is created next year or the year after, we don't have to keep coming back to say, well, okay, well now, it's not just, PAs or RNs or LPRNs or whatever. Now it's this new licensure. The idea is let's just keep it in this broad context of us where there is a statute that kind of broadly defines the medical profession, because that's the nature in the context of this direct contact with a patient.
Well, I think also we want to preserve the hearsay rule because it's governing what comes into evidence and what doesn't. So regardless of how many licensures there are. Any other questions? Senator Shane.
Thank you, Madam Chair. A couple of questions here, if I may. So perhaps a physician may be less likely to lie because of their license and the Hippocratic Oath, but what evidence is there that people are actually less likely to lie to a physician? And I guess I come to this, my background, I'm a veterinarian. I've certainly lived plenty of experiences where people did not reveal the complete truth of what happened with an animal. And I know from firsthand experience, not being the provider on the human side, but friends who are providers and hearing plenty of stories that I don't know that I come to the same conclusion that people are less likely to lie to a physician. I guess, could you speak to that?
Yes, I guess first is this is an exception that has been around since before I started practicing. So it's not some new idea. Again, the fact that we're not creating an exception, right? We're just trying to better marry it to the universe of people that people actually speak to. So I guess my answer is the experience of the legal community and case law that precedes this legislative enactment, which I don't know when it was put in, but it was put in many years ago, all speak to that decision has been somewhat made. But laws change, and so we need to continue to justify those policies. The idea is, again, when I make a statement to a medical professional seeking treatment, the general idea is if I don't define, you're right, people aren't candid about all their problems. When you go to the doctor, you say you're fine when you're not. Sure. But if I'm seeking treatment for something, I need to be theoretically, I need to be as truthful in my description of how long I've had the symptoms, the nature of the symptoms, whatever, or I'm not going to benefit, right? If I don't tell them truthfully what the problem is, the likelihood of them being able to accurately identify the problem and treat it correctly goes down. So my interest is served by being truthful with them. You're right. Sometimes people aren't. None of the hearsay exceptions assume 100% truthfulness, right? That's why we still have to challenge and provide, other testimony to provide context and credibility. But those statements are different from me walking to a police officer and say, I accuse Joey of crime. I say Joey committed the crime. I say Joey confessed the crime to me. Well, there, I could have any number of motives for doing it, and there's really no harm that comes to me directly from my lack of candor to that police officer, right? We don't, unlike the federal government, we don't have a crime for lying to the police. And we can all think of a myriad of examples where someone might accuse someone of falsely confessing to them. So that's an entirely different universe of statement than when I talk to someone in a context where the only benefit would not come from incriminating someone else, but from failing to properly describe how the injury occurred to me. So I hope that makes sense. I don't know.
It does, but to me, it still feels a bit like an argument based on conjecture and opinion, not necessarily rooted in evidence. And I would say that probably goes all the way back to when the hearsay exemption was probably granted. I just question whether or not, we're reaching for opportunities to try to grab hearsay to use as evidence. And to follow that, I guess I'm wondering, has the hearsay exemption for physicians actually made measurable impacts to justice? In that, how many cases was it that hearsay exemption that led to proof beyond reasonable doubt that a person was guilty of a crime, and where it had a major role in the outcome and the execution of justice?
Well, obviously, I'm not in a position to give any kind of a quantitative answer to that. But I can say that, particularly in domestic violence cases, these initial statements to care providers are how crimes are most often discovered. And whatever statements they make to those individuals, I would expect are more likely to be listened to by a jury than a statement that they might make to a police officer, in some other context. I mean, I understand what you're saying, that they're, I don't know if I'd call it conjecture, but I understand that it's not a uh, infallible statement that people only tell the truth to medical personnel. I acknowledge that. But I do know that juries and at least some people have found statements made to medical professionals to be of a different character than a 911 call, or let alone a statement to their friend, um, some other associate of the defendant, or law enforcement. And this rule codifies that it is of a different character.
Thanks for participating in the discussion with me. I appreciate that.
And thank you very much for the opportunity.
Thank you. Committee, any other questions? I have one last question, and again, thank you for the discussion. Did the Kansas County and District Attorneys Association reach out to any civil attorneys?
No, I will say I can't say that we have. I, you know, I guess I can't speak to what their position would be on this, other than um, we see it very often in the context of domestic abuse cases. In the civil context, um, I guess in a personal injury case, if a person tells the nurse that they didn't have any symptoms, and then you know they later want to say that they have pain and suffering from their car crash, I would expect, and again, all this assumes that the patient, the declarant, isn't available, right? If the declarant, if I'm the victim, and I show up in my personal injury case and I say, oh, I have whiplash and I have all these problems, and I've been saying having these symptoms ever since the first day of the crash, there's an entirely different exception that could come in, which is a prior inconsistent statement, right? So what this exception speaks to are times when the declarant, the person who has the symptoms, is no longer available, either because they've died or are unavailable for some other reason. A lot of times, children, right? There may be reasons that they may not be able to testify, but they reported certain problems to their nurse or doctor. There might be reasons why that comes in. But in the civil context, I guess it'd be a personal injury case, and I would think, I could see reasons why both sides would want to know, want a jury to hear what someone said right after or the first time they reported an injury, versus after they talked to an attorney.
Well, thank you. And again, the bill applies in other contexts as well. It could be, I don't know, a contract dispute. And if you're trying to show that, well, the statement made as to your assent to the contract or something was you weren't in your right state of mind or something. But anyway, it's pretty, I appreciate the discussion, and appreciate your willing to think it through, and how this could maybe be workable. Don't know. But thank you. With that, are there any more questions? Not seeing any. Are there any neutral or opponent conferees in the committee meeting room wishing to testify, or on WebEx? Not seeing any. Committee, we do have opponent written only testimony at your desk from Jay Houston Bales and Jorge de Hoyos. I apologize if I didn't say that correctly. Board of Indigent Defense Services Legislative Committee, Kansas State Board of Indigent Defense Services. So with that then, we will close the hearing on Senate Bill 127. We're ready now to open the hearing on Senate Bill 128, creating an exception to certain mandatory reporting obligations for licensed social workers when working under the supervision of an attorney and permitting an attorney to require a licensed social worker to keep ethical obligations of attorney-client privilege while working under the supervision of such attorney. So with that then, a bill brief from the reviser.
Thank you, Madam Chair. Committee, Senate Bill 128, as I said, would create exceptions to certain mandatory reporting obligations for licensed social workers when working under the supervision of an attorney, and would also permit attorneys to require licensed social workers working under their supervision to maintain ethical attorney-client confidentiality. And I'm going to kind of split this brief between sections because it's kind of nearly identical language. It's inserted into the mandatory reporting statutes and then employment statutes related to those. So beginning with sections 1, 3, and 5, these sections amend KSA 382223, 391402, and 391431. And these are statutes that mandate reporting by certain persons who receive information or have reasons to believe or suspect harm is occurring from certain types of abuse against children and adults. 382223 mandates reporting for a licensed social worker who has reason to suspect that a child has been harmed as a result of physical, mental, or emotional abuse or neglect or sexual abuse. KSA 391402 mandates reporting for licensed social workers who has reasonable cause to believe an adult who is a resident of certain facilities or adult care homes that person is being abused, neglected, or exploited or needs protective services. And then KSA 391431 mandates reporting for a licensed social worker as reasonable cause to suspect or believe that an adult needs protective services or is being harmed from abuse, neglect, or financial exploitation. So what the bill would do, and you can see the first example on page 2 in section 1, it would insert kind of identical language into each of those mandatory reporter statutes to create an exception for licensed social workers from those general requirements when the licensed social worker is working under the supervision of an attorney and the reason to suspect that the harm is occurring from the particular or abuse or financial exploitation, depending on the statute, and which triggers that mandatory reporting requirement. That reason is solely arises solely in the course of the attorney's representation or a prospective client seeking the attorney's representation in a civil, criminal, domestic, or juvenile matter. So then moving on to sections 2, 4, and 6, which amend KSA 382224, 391403, and 391432. These are statutes that prohibit an employer from taking certain actions against an employee because of an employee's mandated reporting requirements under those statutes that just previously discussed. Currently, an employer is prohibited from terminating or otherwise impairing or sanctioning an employee because the employee makes a report as required by law. As the bill would create an exception in each of those respective employment statutes related to mandatory reporters for attorneys, and it would allow an attorney to require a licensed social worker with those obligations to maintain attorney-client confidentiality under the Kansas Rules of Professional Conduct. The exceptions for the attorneys would apply when the licensed social worker is working under the supervision of that attorney. The attorney is providing representation or prospective client is seeking the attorney's representation in a civil, criminal, domestic, or juvenile matter. And the reason to suspect or believe that the harm is occurring from the particular abuse, depending on the context, triggering that mandatory reporting requirement arises solely in the course of such attorney's representation or when the prospective client is seeking the representation of the attorney. So then finally, Section 7 amends KSA 656315, which is a statute that provides certain confidentiality requirements and exceptions for information acquired by licensed social workers in the course of their work. Currently, the statute provides that information acquired from a person by a social worker is generally confidential unless certain exceptions apply. However, the confidentiality privilege for information required there is no confidentiality privilege for information required to be reported to a public official. So one of these exceptions applies when a person is under the age of 18 and is the victim or subject of a crime, and the licensed social worker is required to testify on information acquired by the person in relation to a trial or other proceeding where the crime is the subject of an inquiry. Senate Bill 128 would specify that a licensed social worker would not be required to testify on such acquired information when it was acquired solely while working under the supervision of an attorney, providing services to a client in a civil, criminal, domestic, or juvenile matter, or a prospective client is seeking the attorney's representation in the matter. The bill would also provide an exception for information that's generally not considered privileged by reason of it being reported to a public official. The bill would provide the information acquired by a licensed social worker while working under the supervision of an attorney, and the information is acquired solely from the attorney's client or prospective client in a criminal, civil, domestic, or juvenile matter would still be privileged information. And with that, I'd be happy to stand for questions.
Thank you for that thorough bill brief. Appreciate it. Committee, any questions? Not seeing any. Thank you very much. We have a number of proponents wishing to testify in person, and so given the time, we're going to ask that each conferee limit their testimony to 4 minutes, and please keep an eye up here. I will hold up the manila folder when there's 1 minute remaining. So with that then, we will invite Heather Cessna, Executive Director, Kansas State Board of Indigent Defense Services, to the podium. Please introduce yourself and welcome to committee.
Thank you, Chairwoman Warren and members of the committee. My name is Heather Cessna, and I'm the Executive Director of the Board of Indigent Defense Services. We actually requested this bill, and so I was going to give kind of a broad overview of why we brought this to you, but I will probably save some of the more specific aspects for some of the other proponents who are prepared to testify. Basically, the conflict that we're dealing with here is that if you have a licensed social worker who's working under the supervision of an attorney, there's this conflict between their mandatory reporting requirements and the duty of confidentiality that is the linchpin of the attorney-client relationship. And one of the reasons why this has become more and more of an issue for our practice is because it has become a standard across national public defense realms to have a more holistic approach to defense practices, which often includes things like having licensed social workers as part of your defense team that's actively working on a case in order to try to create better outcomes. There's a lot of research out there that talks about holistic defense practices, saving taxpayer money, creating better outcomes, not just for the client, but for the legal system in general, including even victims in the case, so that the people who are the subject of the charged crimes in our case, since I'm talking about this from a defense perspective, criminal defense perspective, it gives them the opportunity to be able to be better serviced, to meet any needs that they may have in order to get treatment or things like that so that they can be more successful on probation by having those licensed social workers there. Oftentimes it helps with mitigation information that they're gathering for sentencing purposes so that there's a better overall outcome when it comes to sentencing decisions. So there's a variety of reasons why having licensed social workers on the defense team working under the direct supervision of the attorney is important to this practice, but there is this statutory conflict here. And so we worked with a variety of entities to try to come up with language that would be able to create that narrow exception of somebody who's actually working under the supervision of the attorney and therefore as part of the team is subject to that same confidentiality requirement as the attorney, to be able to not have to have that conflict or have to be cut out of vital parts of the defense practice in order to participate as a full member of that team. And I'm happy to stand for questions, or I can wait until the end. But like I said, I know there's several other people who are going to talk more specifically about some of the aspects of this, so I'll save that.
Thank you. We'll appreciate the testimony, and we'll go ahead and hear all the proponent conferees, and then we'll have questions at the end. So if you can stick around, that'd be great.
Thank you.
Thank you. And next, we will hear from Karen Levy, Assistant Director of Special Projects, Kansas State Board of Indigent Defense Services. Please introduce yourself and welcome to committee.
Good morning, and thank you for having me today. My name is Karen Lev, and I'm the Assistant Director of Special Projects at BIDS. I've previously submitted written testimony, so today I want to spend my time really highlighting the importance of the licensed social worker on the defense team in support of this bill. So by way of background, I myself am an attorney. I also hold a master's in social work and held a license in social work for approximately 7 years. Before joining BIDS, I worked as a public defender at the Bronx Defenders, which is a holistic public defense office that uses attorney and non-attorney advocate teams in representing clients. So as a result, I regularly worked on these sort of teams that Ms. Cessna just spoke about alongside licensed social workers. And the purpose of assigning these legal teams instead of just a lawyer is to be able to provide specialized, client-centered representation that targets not just the case that brought them here, but also the underlying factors, so social and economic factors that brought contact with the system. And this type of holistic team-based defense has been shown to help improve case outcomes, but also help reduce recidivism overall. Having a social worker on the legal team, in my experience, was vital to the client and to the legal team as a whole. Social workers on the legal team enhance client representation and advocacy and allow the attorneys to better and properly serve their clients. Social workers are adept at using empathic interviewing skills and have strong assessment skills that allow them to get to know clients in ways that an attorney simply cannot. The information that social workers gather from their clients help clients advance their legal goals through mitigation, through release planning, and social workers help educate all members of the system about who our client is beyond just the case that they are facing. Social workers also have training and education in mental health and addiction and assessments that help lawyers understand the very specific needs of their clients, and they're able to use that knowledge to then connect clients to community resources and service and supports that help clients address those underlying issues. The attorney-client privilege is vital to the attorney-client relationship. It exists to encourage full disclosure so that attorneys can give the best representation possible. But when members of a united team who share the singular goal of representing and advocating for that client have different disclosure obligations, it creates confusion and also threatens to disrupt that important relationship. So a client may feel confused about who they can and can't talk to on their team, what they can and can't say, and significantly may elect to not have a social worker on their case at all, even though that would benefit their legal outcomes. A social worker on the legal team is part of the advocacy effort of the attorney, and they should be able to fulfill those obligations to their client accordingly, and this exception allows just that. It allows the legal teams to function properly and provide strong legal representation and advocacy by allowing social workers to conduct their work more fully in support of their client's case. I'll be available for questions after.
Okay, great. Thank you for your testimony. Next, we will hear from James Pratt, an attorney with Pratt Law. Please introduce yourself and welcome to committee.
My name is Jim Pratt. Does the red light mean it's on? I'm an attorney in Wichita, Kansas. I'm a former public defender, and now I have a private practice where I do a lot of appointed work. I first became interested in social workers helping me in my cases when I took a seminar where there was a social worker. And one of the things that I would always ask in a client interview is, have you ever been abused? According to the social worker, that is completely wrong. That is not what you ask somebody. You ask them things like, how were you disciplined when you were a child? Because the abuse of one person is not the abuse of another person. So I was trained in the law. I never took a course on how to interview a client. Unfortunately, Washburn Law School never offered that course, how to relate to people. So I don't have great interpersonal people skills. I have a hard time interviewing my clients, and I sort of feel like I'm prying. So after I took this course with this social worker, I tried to find out how I could get a social worker to do these interviews for me. As I said in my written testimony, I have to humanize my client to a judge who only sees a pre-sentence report and maybe a probable cause affidavit. So I looked around and I realized that the law in Kansas was against me. I could not get a licensed social worker to do these interviews for me. I sort of worked around it by finding an unlicensed social worker, somebody who has a bachelor's degree, has the same training, but that's all she can do for me is the interviews. And they help tremendously to dig out a lot of facts about my client's life and how I can present them to the judge. It is not somebody who has committed a crime, but somebody who is a human being, who is redeemable, who needs a second chance. And fortunately, through the work of this social worker, I've been able to do that a whole lot better than I have ever been able to do that before. I am always very passionate about representing my clients, but there are things that they are not willing to tell me. And they are already inundated with people who they do not have privilege with. If there's a drug and alcohol evaluation, that is going to the court to help them get bond. If there is a psychological evaluation, that is going to the court so the court can see what sort of mental problems they have. But we need something to allow them to open up to somebody to tell us about their lives that may not be on a psychological evaluation or may not be on a alcohol and drug evaluation, something that digs down to who they are and how they got the way they became and how they got to where they are standing in front of the judge. And Your Honor, I think that, or excuse me, Chairperson, I believe that this is the right.
I've been called worse, so it's all right.
I haven't. I believe that this bill will help that, help me as an attorney, help all attorneys in the state of Kansas to humanize our clients. Thank you.
Thank you. And I just want to be clear with our conferees. This means you have 1 minute left. It doesn't mean stop, but so I don't mean to cut anybody off before the allotted time. So thank you for that testimony. So next we will hear from Melody Brannon, Federal Public Defender. So please introduce yourself and welcome to committee. And this means 1 minute left, not stop. So if you need to continue, thank you.
Does that mean I can have his extra minute? My name is Melody Brannon. I am the Federal Public Defender for the District of Kansas. I have been a public defender for almost 35 years now. In that time, I have represented hundreds, if not thousands, of people. And every time I've represented someone, I've come to them honoring my obligation to confidentiality and loyalty. That is the bedrock, as you've heard, of an attorney with the client, to honor that confidentiality and that loyalty. And our clients must have confidence in us and those that work with us, not only for their own benefit, but for the entire legal system to work. When I put together a defense team for a client, every member of that team, investigators, paralegals, student interns, they are all bound by my obligation of confidentiality and loyalty. Every member of that team, except licensed social workers in Kansas. And when I learned of this, I'm sort of like Jim, when I learned of this, I didn't believe it at first. I just assumed that my sacrosanct obligation of confidentiality was paramount to any other obligations for someone who was working for me in the course of representing a client. And I was wrong. I have to say that in looking at these statutes, the current statutes, I don't think that these statutes contemplated the particular conflict that we're bringing to this committee between the attorney-client obligation and the mandatory reporting duty of the social worker. And that's where we're asking for this very narrow fix. In the last decade or so, I will say that I have become acutely aware of how incredibly valuable social workers, licensed social workers, are to our work and our holistic work. They're helping us find better and new ways to help clients, more efficient ways to work, identifying resources and support for our clients as they reintegrate into the communities. We represent people who are on pretrial release, who are on supervision, and these sorts of supports, helping them reintegrate into the community and comply, not only benefit our clients, but their families and the communities and the public. And that's how I learned to look at licensed social workers, connecting us, our clients, with those resources so that they can succeed in the community. The current law is really a barrier to this. Our current workaround right now, we have 2 licensed social workers in our office. Our current workaround is to ask our clients to sign a waiver. If we're going to put a social worker on your case, you have to waive confidentiality. That's not a sustainable solution. It's confusing, it is disruptive, and it's just unworkable. A more sustainable but a really unfortunate solution would be to only use unlicensed social workers. But this has many things that are really not what we want. I think we want licensure. We want professionalism. We want that continuing education. I want a licensed social worker that can supervise interns to work for us so that those social workers can go out and be employed in this way. But by using unlicensed social workers, that discourages licensure for the employment and work in the legal field. 128 offers a very narrow exception. Mandatory reporting makes sense in many areas, but for this particular unique conflict that we're presenting, I think SB 128 offers a solution. We have a holistic approach, and for that reason, we want to make the best team we can for our clients, for the legal system, and for the community. I will remain available for any questions. Thank you.
Great, thank you, appreciate it. Next, we will hear from Noelle O'Neill, LMSW, Kansas Federal Public Defender, Mitigation Specialist. Please introduce yourself and welcome to committee.
Chairperson Warren and members of the committee, my name is Noelle O'Neill, and I am a licensed social worker with the Kansas Federal Public Defender's Office. I appear before you today to explain how the proposed Senate Bill 128 would impact social workers such as myself. Before I get started, I think that it's important for you to hear a little bit about me and what brought me here. I grew up in the small community of Norwich, Kansas. When I was in the 3rd grade, my teacher asked what I wanted to be when I grew up. And when I answered her, I said my response was a police officer. She asked all my classmates that question, and she kept it in a notebook that she kept in her desk until we graduated. At that time, I was headed to college to pursue a degree in criminal justice. My senior year, I was an intern at a probation office, and this is where my career changed course. I recognized there were individuals who had been released from prison who struggled to meet the requirements of their probation, not because they didn't want to succeed, but because they were dealing with underlying issues that had not been addressed. In 2017, I started my career at Wyandotte Mental Health Center. I worked alongside individuals who were on probation, but who had also been diagnosed with severe and persistent mental illness. I was a part of the team that established the mental health court in Wyandotte County, and I was the case manager for the first ever graduate of that program. In 2022, I got the honor of being another first. I became the first social worker hired by the Kansas Federal Public Defender's Office. In this role, I support clients who are at risk of going back to prison by connecting them with the necessary supports, including mental health treatment, substance use support, and housing assistance. Another component of my job is sentencing mitigation. This is the process of uncovering the events that led to an individual's involvement in the criminal legal system. So just like it's important for you to get to know me and my background, it is important for me to get to know my clients and the events that led them to where they are today. Every day, I get the opportunity to hear our clients' stories that are often painful and complex. The skill it takes to uncover these stories requires something fundamental, trust, which is the cornerstone of effective social work practice. When clients fear that certain information they disclose to me may extend beyond their legal team, it compromises our therapeutic relationship. As a licensed social worker, I take great pride in my profession. Obtaining my social work license required me graduating from an accredited university, completing internships in both non-clinical and clinical settings, passing the Social Work Board's master examination, and my ongoing participation in continuing education and training programs. Throughout the social work field, because of this high standard of service, licensure is encouraged. It troubles me to hear that under current law, to effectively serve within legal defense teams, I'm indirectly being asked to set aside the very thing that makes me good at my job, my license. Additionally, something I know that the committee will consider is the question of risk. While mandated reporting requirements serve necessary purposes in most settings, such as schools, the legal defense team is unique. By having social workers embedded in defense teams, there's actually less risk than what there might appear to be on the surface. In the course of this work, much of the information that might typically trigger a mandated report is historical in nature or already documented in police reports and court records. Additionally, many of our clients are either in custody, where they pose no risk, or under supervision, where they are being monitored by an officer of the court. So, just as my early aspirations have evolved, and I have found more effective ways to help people untangle their lives from the criminal justice system, that same system has an opportunity to evolve by allowing qualified social workers to use their skills to create better outcomes for our clients and for our communities. Thank you for your time.
Thank you. Next, we'll hear from Michelle Ewert, Director of the Washburn Law Clinic. Please introduce yourself and welcome to committee.
Good morning. Thank you so much for letting me testify in this important legislation. My name is Michelle Ewert. I am a professor of law at Washburn University and director of the Washburn Law Clinic. I want to make clear I am here in my individual capacity as a member of the faculty and director of the Law Clinic. My statements do not represent the official position of Washburn University or Washburn University School of Law. In the Washburn Law Clinic, my students and I provide free legal services to low-income Kansans who would otherwise not have access to counsel. We do family law cases, housing cases, public benefits cases, a whole range of cases that affect low-income people. In my prior life, I was a civil legal services attorney and spent about half that time representing survivors of domestic violence, child abuse, and elder abuse. I'm also a licensed foster parent. Since 2018, I've been providing emergency and respite foster care to Kansas youth aged 10 to 18, so I care deeply about eradicating sex abuse and child abuse in any form. I care deeply about protecting vulnerable Kansans. As a lawyer, I also care about making our legal system work better, and that's what this bill would do. It would continue to protect vulnerable children by keeping in place mandated reporting requirements for most social workers and all other mandated reporters. Because remember, it's not just social workers who have these responsibilities, it's also medical personnel, school personnel, first responders, and child care providers. None of that would change. Children would still continue to be protected. However, what this bill would do would allow attorneys like me to provide better representation to our clients, to engage in a more client-centered type of representation. Because we know, as you've heard, social workers have training and expertise that we as lawyers don't have. They can help us interview more effectively, understand our clients' lives, so we can communicate that more clearly to judges, so judges have more information to make better decisions. They can help us connect our clients to necessary community resources that will help meet social and economic needs. This is so important. The Washburn Law Clinic would like to actually incorporate Washburn social work students into our legal teams. But right now, this conflict between the students, the social work students' duties of mandated reporting and our students' duties of confidentiality are in conflict. That creates a barrier to us providing the best representation. I urge you as a committee to vote favorably because this bill is a win-win. It will continue to protect vulnerable children, but will also allow lawyers to do a better job representing clients and the court system to function better. Thank you so much for this opportunity.
Thank you. And next we will hear from Courtney Ellis, Midwest Innocence Project social worker. Please introduce yourself and welcome to committee.
Hi, Hi there. My name is Courtney Ellis, and I'm a licensed master's level social worker working at the Midwest Innocence Project. I provide mental health and reentry services to individuals who have been wrongfully incarcerated and are integrating back into society after incarceration. I'm in strong support of Senate Bill 128, which recognizes the necessity of mandated reporting exemption for social workers, licensed social workers operating under the supervision of attorneys. In my role, I work directly with the legal team, providing mental health and reentry support to my clients, as well as working with their families to ensure a solid home plan. There have been instances where my background in social work could have been valuable in assisting with the legal investigations, but the constraints of mandated reporting laws have made it difficult to engage in that capacity. Social workers embedded within the legal teams serve a unique function, bridging the gap between advocacy, mental health, and reentry preparation. However, under these current mandated reporting laws, we face ethical conflicts that can disrupt both the legal process and our ability to provide meaningful support. For example, while working to develop a stable home environment for a client's reintegration, I may meet with family members or community connections who are vital to that transition. In these interactions, I might learn that under current law, something that could trigger a mandated report. In such situations, reporting may not always be in the best interest of the client or the broader pursuit of justice, creating a dilemma where my legal and ethical responsibilities are at odds. This conflict can discourage individuals from fully engaging with the support systems available to them and can even create barriers to effective legal advocacy. Additionally, no social worker should have to choose between maintaining their professional license and serving as a valuable asset to the legal team. Yet, under current law, some social workers may feel compelled to let their license lapse to avoid mandated reporting obligations that conflict with their role in legal advocacy. This is an unnecessary and unjust choice that limits the availability of trained professionals in a space where their expertise is critically needed. This bill strikes the right balance between legal and social work ethics, allowing social workers to provide critical support without compromising the attorney-client relationship. This exemption ensures that individuals and their families can access the help that they need without fear of seeking assistance that could unintentionally harm their case. By clarifying the role of social workers within legal teams, this bill strengthens both the legal process and the rehabilitation of seeking to rebuild their lives. Thank you.
Thank you. Do we have any other persons in the committee meeting room or on WebEx wishing to testify as a proponent? Not seeing any, then committee, I want to direct your attention to proponent written testimony at your desk from Becky Fast, MPA, LCSW, Kansas Chapter Executive Director, National Association of Social Workers, as well as from Tim Davis, PhD, LSCSW. And with that then, any questions from the committee? Not seeing any, so you all were very thorough. Thank you for following along with the timing that we had as well. So thank you for your testimony today. Do we have any persons wishing to testify as neutral or opponents to Senate Bill 128? Not seeing any, then we will go ahead and close the hearing on Senate Bill 128. Committee, we do have some time to work some bills, but I'm hearing some amendments aren't quite ready yet, so please have those ready. We will continue to look to work bills this week as well as on Monday. For the rest of this week, tomorrow we are expecting some weather, so we are going to meet on WebEx. So please look for an email from Tanner for a WebEx invitation for our meeting tomorrow. We will still be proceeding with hearing bills as scheduled. However, we can only work bills if we are in the committee meeting room. So we will not be able to work bills tomorrow, but we will continue with our hearing. If we're not here on Thursday due to weather, we will continue with our hearings on WebEx, but again, we're not able to work bills unless we're in the committee meeting room. So look for a very busy Friday. We do have, I think, 4 bills scheduled for hearing on Friday, and we will try to have some time to work bills. And on Monday, our plan is to only work bills previously heard. So please make sure you have your amendments to Natalie and ready for those to discuss throughout the week. And our last opportunity to work those bills is Monday, February 17th. So with that then, I hope everyone travels safely with the weather we have coming, and want to thank everyone for their work today. And with that, then, the meeting is adjourned.